Hello and welcome to the first in a series of webinars given by the 2TG Personal Injury Group, focusing on COVID-19 and the potential legal consequences. I'm Helen Wolstenholme. I've been a barrister at 2 Temple Gardens since 2004, and I specialise in personal injury and clinical negligence work. I'm going to be speaking alongside Lucinda Spearman. Lucinda became a tenant at 2TG last year, and I had the pleasure and privilege of being one of her pupil supervisors. I can attest to her overall brilliance.
Hi everyone, I'm Lucinda. As Helen said, I recently joined 2TG, so I do just about everything that comes through the Chamber's door, including a lot of PI work. It's great to be giving this webinar with Helen, who as a supervisor was and continues to be a brilliant example of how to succeed at the bar.
Please do feel free to ask us questions during the course of the webinar by using the chat function. We'll do our best to answer them. If we don't get a chance to, please do contact us by email after the end of the webinar. Now, the PPE shortage has been widely publicised. It feels like almost every day new concerns and complaints are being reported by NHS staff, bus drivers and care home workers about the lack of suitable equipment. Announcements are also being made about the vast supplies of PPE coming into the system, whether from abroad or from volunteers making kit from their own homes. And devastatingly, deaths from COVID-19 of employees working at the coalface are being reported. In all of this noise, it seems worthwhile to us to just pause for half an hour to think carefully about the legal landscape surrounding the shortage of PPE and to consider some of the key issues which are likely to arise in the litigation which will inevitably follow. I want to turn to the first slide now, which sets out the legal framework. In considering the duties owed by an employer in relation to PPE, the starting point is the Personal Protective Equipment at Work Regulations 1992. These owe their origin, of course, to the PPE 89656-EC directive. The 1992 regulations set out in detail the duties owed by an employer in relation to PPE. They are comprehensive. They cover the duty to provide it, the duty to undertake assessments of suitability, the duty to maintain and replace PPE, and information, instruction, and training on it. The first point, though, to bear in mind is that the provision of PPE should only be adopted as a last resort if other means of avoiding a risk can't be adopted. This was made clear in the directive, and it's also echoed in Regulation 4 of the 1992 regulations, which provides that every employer shall ensure that suitable protective equipment is provided to his employees who may be exposed to a risk to their health or safety while at work, except where and to the extent that such risk has been adequately controlled by other means which are equally or more effective. Thus, if an employer is able adequately to control the risk posed by COVID-19 in the community by, for example, social distancing or requiring employees to work from home, there is no duty to provide PPE. Unsurprisingly, that's why the issues relating to PPE have arisen in sectors of the workforce where that is simply impossible. So the healthcare sector, care homes, public transport, supermarkets. Breach of the 1992 regulations no longer gives rise to civil liability. That's the effect of Section 69 of the Enterprise and Regulatory Reform Act 2013 in respect of accidents at work. All cases against an employer must now be brought in negligence. So put simply, an employee must show that their injury was a foreseeable consequence of their work and that their employer breached the common law standard of care. In assessing what the standard of care is, the PPE regulations are plainly still relevant, just like all of the other six-pack regulations. And the courts have consistently emphasised, since Section 69 was enacted, that a reasonable employer should be aware of the regulations and should comply with them. So the working assumption of most of us practicing in this field has been that Section 69 has made very little difference to the duty of care owed by an employer. Look, for example, at the decision in Gilchrist and Asda, which Lucinda will come on to talk about a bit later. But we consider that the COVID-19 pandemic is likely to test that assumption. The courts are likely to be far more prepared than usual to look beyond the strict language in the regulations and to consider seriously arguments relating to reasonable practicability, which to date have been dismissed. The common law duty of care is also informed by approved codes of practice, HSE guidance, and other government publications. And I've put an example of these on the slide. These are coming thick and fast, and it will be essential for an employer to show that they're keeping abreast of them. Now, finally, another piece of legislation to bear in mind is the Employers' Liability Defective Equipment Act 1969. This imposes liability on an employer for the faults of suppliers of work equipment. Now, having set out the legal framework, I'm going to hand over to Lucinda, who's going to look at the issue at the forefront of concerns relating to PPE, the duty owed by an employer to provide it.
Thank you, Helen. As you say, the duty to provide PPE is going to be at the front and centre of litigation concerning the shortage, which is widespread even in areas that need it the most. In statistics published by the British Medical Association on the 24th of April, it was reported that around 50% of doctors working in high-risk areas, so that will include ICUs, high dependency units, and respiratory wards, had a shortage or no supply at all of long-sleeve gowns and goggles, whilst 56% said the same for full-face visors. In addition, about 50% of doctors working in other areas said there was a shortage or no supply at all of scrubs and eye protection. And just under a third of all doctors said that they were sometimes pressurized to work without adequate protection. On the next slide, we can see that the extent of the shortage is no better summed up than by the revelation at the end of March over Twitter that NHS procurement had been forced to approach a medical clothing fetish company in the northwest of England in order to plug gaps in their stocks.
Wow.
The scopes for claims by employees in the health service alone is very sizable, let alone in the other lines of work that Helen has outlined. Regulation 4.1 is set out on the next slide. And what we can see first is that it imposes what looks like an absolute duty, as there is the use of mandatory language. In others of the so-called six-pack regulations, a defence is built into the regulation framed around the concept of reasonable practicability. So the employer has a duty to an employee in some way, but only insofar as it's reasonably practicable to fulfil it. Now, although Section 69 means that employers will no longer be strictly liable for breaches of the PPE regulations, claimants may point to the absence of any language limiting the extent of an employer's liability, arguing that the duty should be understood to be pretty absolute. Another important aspect of Regulation 4.1, as Helen's highlighted, is that the duty generally only comes into play as a measure of last resort. But of course, for defendant employers who are operating on the front line of the pandemic, they're unlikely to be able to say that there are other ways of adequately protecting employees without the use of PPE, given that the virus is so easily transmitted. So whilst other measures such as regularly disinfecting work premises and providing hand washing facilities are still worthwhile, the importance of making efforts to obtain appropriate PPE for workers on the front line cannot be underestimated. On the next slide, we can see that another important aspect of the regulations is to provide equipment that is suitable. There are a number of factors that go towards suitability under Regulation 4.3, and 3A and 3C are of particular interest in the context of COVID-19. 3A imposes a duty on an employer to ensure that the equipment provided is appropriate for the risks involved. Courts are likely to measure appropriateness by looking at contemporaneous guidelines from organisations such as the WHO, Public Health England, the Health and Safety Executive, and the government. But this is likely to be a very fraught area in litigation because the guidance about what appropriate PPE actually is for medical staff working around COVID patients has changed almost daily since the outbreak. So the chronology of what guidance was issued and when it is alleged that the PPE was inadequate in a given claim will be very important. The next slide shows reports in the press this week of 2 doctors who are planning to sue Public Health England over changing guidance. They say that guidance has changed in accordance with stock availability as opposed to scientific evidence. And if that's the case, then it's easy to see how satellite issues, such as what was actually appropriate at the time, guidance aside, might arise in litigation. Moving on to the next slide, looking again at Regulation 4.3. Looking now at 4.3c, that requires the employer to check that the PPE is capable of fitting the wearer correctly. On NHS wards, staff have to undergo a fit test before being provided with an FFP3 mask. That test involves an employee wearing the mask and seeing how long it takes before they're able to smell a scent that is sprayed around their head. If the employee can smell the scent, the mask isn't working properly, and they should not work around confirmed or suspected COVID patients. Now, while some NHS trusts will have the resources to implement these fit tests, smaller or non-clinical organisations are obviously less likely to be able to do so. And so that will present claimants with opportunities to frame a claim around a failure to get PPE properly fitted. That means that special attention should be paid by employers to the fitting of masks in particular. Helen's now going to take us through the duty on the employer to carry out risk assessment.
Thanks, Lucinda. The duty upon an employer to conduct a risk assessment is now very much part and parcel of the common law. In Kennedy and Cordia Services, the Supreme Court emphasised that it has become generally accepted that a prudent employer will conduct a risk assessment in connection with its operations so that it can take suitable precautions to avoid injury to its employees, regardless of whether or not it has a statutory duty to do so. I want to start by emphasising Regulation 6.3. An employer must review a risk assessment if there is any reason to suspect that it's no longer valid or there has been a significant change in the matters to which it relates. Now, COVID-19 is likely to be considered in almost all jobs to be a significant change, mandating the review of a risk assessment. On that basis, the first point to look for in any case involving an employee contracting COVID-19 will be whether or not a fresh risk assessment was brought in after the risks were known. If one wasn't, then I suspect it will be a slam dunk case of negligence. It's also worth noting that Regulation 6.1 provides that before choosing any PPE, an employer shall ensure that an assessment is made to determine that the PPE is suitable. Lucinda has already explained what suitable means in this context, but I think it's interesting that it talks about the risk assessment being done before the PPE is chosen. It seems likely that in the rush to secure supplies, questions relating to whether a particular mask or a particular apron are suitable may well be overlooked. Some equipment, possibly that made by new suppliers or volunteers working at their kitchen table, may not be appropriate given the risks involved. A risk assessment should also consider the individual characteristics of the employee. We are all learning more every day about COVID-19 and who is most at risk. At the start of the pandemic, it was widely publicised that the elderly or those with serious underlying health conditions were particularly vulnerable. However, as the weeks have gone on, the statistics have shown that workers from ethnic minorities are at a disproportionately higher risk of death from the virus. The Health Service Journal revealed last week that whereas BAME staff make up 21% of the NHS workforce, 63% of NHS staff who have died were from an ethnic minority background. Dr. Parag Singhal of the British Association of Physicians of Indian Origin was reported last week as saying this: hospitals should have started risk assessment of the staff when the issue of ethnic minority deaths came to notice. This is still not happening. This issue then may also need to be reflected in a risk assessment relating to PPE. Should more vulnerable employees be required to don additional kit? So, for example, in a supermarket, not just gloves, but also masks or visors. Or if stocks are scarce, should more vulnerable employees be prioritised for the provision of PPE? All interesting stuff, but I'm now going to hand you back to Lucinda, who's going to look next at training.
So moving on to the next slide, we're now going to look at Regulation 9. which provides for the employer to provide information, instruction, and training as is adequate and appropriate to an employee using the PPE provided. Now, of course, many employees, such as bus drivers, who are now being asked to use PPE will never have done so before. So training is especially important if equipment is being used. The research has also shown that masks can cause more harm than good if they're not properly worn. And so that's very important too. Employers should consider especially how should PPE be fitted to guard against the risk of contracting the virus? How should it be kept when it's not being worn? When and how should it be cleaned or disposed of? On the next slide, it's also interesting to note that in Regulation 10.2, there is a counter duty on employees to use their PPE in accordance with their training, and that will assist defendants in making contributory negligence arguments, which Helen's going to talk about later. Helen's now going to look at the issue of defective equipment.
That's right, Lucinda. Regulation 7.1 provides that every employer shall ensure that any PPE provided to his employees is maintained, including replaced or cleaned as appropriate, in an efficient state, in efficient working order, and in good repair. This is likely to be highly relevant. We've all seen the media reports of staff being asked to reuse PPE, which is designed and marketed to be single-use. And Lucinda has already talked about the ever-changing Public Health England advice to clinical workers about what is the right equipment that they need. It seems inevitable that when stocks are low, emphasis is likely to be placed on those words replaced or cleaned as appropriate. What is appropriate now may be very different from what was appropriate before COVID-19 struck. An employer may wish to say that it's appropriate, given that stocks are low, to clean and reuse items, or to change them less frequently. An infected employee who has been asked to reuse kit, which was designed for single use, is very likely to have a different view. But think of an employee who's working in a workplace where there is simply not enough kit available. In that situation, they may say that the kit that is there should be conserved as much as possible. It should be cleaned as appropriate and replaced less often. I also want to consider the issue of defective equipment because I mentioned in the introduction that employees may wish to rely upon the Employers' Liability Defective Equipment Act, which has survived Section 69 of the ERA. This is a short statute, possibly offering some bedtime reading, which makes employers strictly liable for defective equipment that causes injury and has been supplied by a third party. It provides that where an employee suffers personal injury in the course of his employment in consequence of a defect in equipment provided by his employer for the purposes of the employer's business, and the defect is attributable wholly or partly to the fault of a third party, the injury shall be deemed to be also attributable in negligence on the part of the employer. So the points to emphasise there, first of all, there must be a defect in the equipment. But it's been held by the courts that this should be given a wide definition. For example, in Ralston and Glasgow Health Board, the fact that soap was materially more irritant than other soaps meant that there was liability for dermatitis. The defect must also be attributable to the fault of a third party. In this case, it's unlikely that any employer is going to be making their own kit, and so most of the time, the defective equipment that does come in will be attributable to another party. But given that kit is being obtained in a rush from many new suppliers, be they well-meaning volunteers making kit at their own home or indeed in the school science lab, to fashion labels who are repurposing factories in order to make aprons rather than handbags, it's highly likely that the usual quality control measures will not be implemented and that some defective kit is likely to come into the system. This act means that an employer would be liable for injury caused by that defective kit, even without fault or proof of negligence on their own part. So an employee wouldn't have to say that the employer had acted unreasonably in sourcing or supplying the kit. They would simply have to prove that the kit itself was defective. It's worth also bearing in mind that we're not just talking about injuries of COVID-19 here. But also think, for example, about an employee who might trip over a gown because the fastening mechanism doesn't work properly and is defective. That employee may suffer a fracture because they have tripped on their gown. In that case, they could also bring a claim under the Act. I now want to turn to the next slide, which addresses causation. So establishing breach of duty on the part of an employer is likely, we believe, to be a fairly low hurdle for a claimant to pass, but causation is likely to be much more challenging. Now, that, of course, is because of the prevalence of COVID-19 in the community, its transmissibility, and in particular, the lack of tracing data in the UK. So it's going to be a challenge for an employee to prove that their employer's breach of duty is what caused them to contract COVID-19. It'll be particularly challenging if the employee doesn't live alone and if there's evidence that they went to other places than work. While at first blush this might seem like something of an insurmountable challenge, it's worth remembering that the court only has to consider the issue on the balance of probabilities. Since the lockdown was imposed and social distancing measures were introduced, the infection rate, particularly amongst the working age population, has fallen dramatically. So causation is likely to be much easier to establish now than it was at the start of the pandemic. It's also worth thinking about the nature of the claimant's role. Causation is likely to be easier to prove if an employee works in the healthcare setting or in a care home, compared, for instance, to an employee working as a delivery driver for Amazon. But testing, alongside PPE, of course, is dominating the headlines. And in respect of causation, both testing and PPE have a key part to play. That's because the employee will have to prove that the breach caused or coincided with the contraction of the virus. The more the workforce is tested for COVID-19, the easier it will be to pin down the issue of causation, because timing of the infection will be possible to determine. It may be that an employer did have very serious issues relating to COVID-19 and PPE early at the start of the crisis, but that now or in the future, they will be able to obtain much more kit. In that case, it will be important to check whether the infection was contracted at the same time as there was a lack of kit, or whether it was contracted once the employer was able to fulfill its obligations. I'm now going to hand over to Lucinda, who's going to give some specific guidance on defending claims.
So what many defendants will want to know is, given that strict liability has been removed under Section 69, would it be a defence for employers to point to the fact that they were operating in unprecedented circumstances? And what about the fact that PPE simply wasn't available? As Helen has said, post-Section 69, the courts have repeatedly held that the health and safety regulations inform the standard of care imposed upon employers in negligence. The results of cases suggest that if a claim would have succeeded pre-Section 69, it will succeed post-Section 69. In Gilchrist and Asda stores, which is on this slide, the claimant alleged that Asda had failed to provide her with a suitable stool to stand on when she was hanging clothing on racks 7 foot above ground and fell, injuring herself. On the slide are the arguments put forward by the claimant's counsel, which were accepted by the court, even though breach of duty was not made out. The first proposition accepted was that employers remained under a statutory duty to comply with health and safety regulations, and that those might define the scope of the duties at common law. Second, an employer who breached a regulation and was thereby committing an offence could hardly argue that he was acting reasonably. Importantly, it seems that it was also accepted that the existence of a regulation would demonstrate that the corresponding harm in question would be foreseeable at common law. On the next slide, similar principles were recognised in the case of Tonkins, which is an unreported case decided by the High Court in Exeter. Mr. Tonkins claimed for his injuries after falling off the back of a scaffold tower at work. The claim, which relied on the provision and use of work equipment regulations, failed, but the court made a number of noteworthy obiter comments about Section 69. First, it was said that Section 69 would not preclude a claimant from arguing that there had been ipso facto negligence on the basis that the defendant had breached one of the health and safety regulations. The judge then went on to say that if Parliament had intended to emasculate the statutory duties, it would have repealed them altogether. Now, these cases might suggest that Section 69 has had little real impact on the results of claims, although it has undoubtedly reversed the burden of proof, and for that reason, in claims concerning the PPE regulations, as with claims made under the other regulations, expert evidence is likely to be of significant importance. But does this mean that employer defendants in the current pandemic will be likely to be found liable for failing to meet their duties under the PPE regulations? Well, we think not on the whole. The courts are likely to be sympathetic to the extraordinary circumstances in which employers were operating. The focus on the factual background to claims arising out of the PPE shortage should not come as a huge surprise if we remind ourselves that claims will be being brought in negligence. And so the court will be considering the usual principles with which we're all familiar. What duties are fair, just, and reasonable to impose? To what extent was harm foreseeable? Moving on to the next slide, it's important to note that if this defence is to be successful, much will turn on the evidence that employers have of what they did and when. It will be important to show what attempts were made to obtain equipment and why they were unsuccessful. One factor that's likely to be relevant is if the equipment, although available, was very expensive. That is, if the defendant has compelling evidence of its limited financial resources. Evidence of the alternative measures taken to supplement or substitute PPE will also be relevant and will go towards creating an overall picture of how diligent a given employer has been. Where an employer in the same industry to the defendant employer has been successful in meeting its duties, this will probably impact upon the strength of the defence. The next slide shows reports at the end of March that Ocado had ordered 100,000 tests for its drivers. If market competitors haven't provided tests at all, a court is likely to want to know why. What about the argument that if an employer doesn't have adequate PPE, it should simply shut its doors to business? Well, case laws establish the general principle that an employer may be under a duty to dismiss an employee if it cannot provide adequate PPE for them. So claimants may make this argument to argue that an employer during the pandemic should have closed shop and furloughed its employees if they had no adequate equipment. In CAUSATION, on the next slide, the claimant was predisposed to asthma and was exposed to tyre fumes at his employer's factory. The question for the court was whether, and if so when, the claimant's employer should have dismissed him once it was discovered that he was vulnerable to developing the condition. Now, the case established a general principle that whether or not an employer is under a duty to remove an employee from work will be dependent upon the magnitude of the risk involved, to be assessed on the facts of each case, looking at the actual nature and extent of the known risk. On the next slide, Lane Group and Farmerlow, which was an employment tribunal case brought under the PPE regulations. The claimant worked in a distribution warehouse and had psoriasis, which meant that he couldn't wear the protective boots provided to other warehouse employees. His employer had been allowing him to wear his own shoes, but on a health and safety inspection was informed that this was unacceptable. The defendant dismissed the employee, who brought a claim for disability discrimination. And the tribunal followed CAUSATION, holding that the employer was under a duty to dismiss the claimant where suitable PPE could not be provided per the regulations. But it's worth bearing in mind that CAUSATION and Farmerlow are pre-Section 69 cases, and so the courts were considering the duty to dismiss in the context of a strict liability regime. There's likely to be a bit more flexibility today. So if this argument's raised, defendants should place emphasis on the consideration they had to give to competing interests at the time of the COVID outbreak. The obvious defence in the clinical context is that for a hospital or care home to shut its doors would be to withdraw an essential public service in time of crisis, and would mean that they were abandoning patients already in their care to whom a tortious duty was owed. In the case of private care homes, of course, both tortious and contractual duties will be an issue. What about the non-clinical settings, such as a supermarket? As we can see on the next slide, a claim has already been issued in Illinois by the dependents of a Walmart employee, Wando Evans, who contracted COVID-19 at work and sadly died at the end of March. Part of the pleaded case is that Walmart failed to provide masks and gloves to prevent the spread of the virus. Here you can easily see how defendants might be in a trickier position as to whether they were obliged to close. It is surely reasonably practicable to shut one branch of a chain as big and profitable as Walmart, thus requiring customers to go to another nearby branch in order to protect employees. The court may well be less sympathetic to a defendant's argument that they had to stay open where the motivation to do so was profit. If an employer has been unable to obtain PPE but has continued to operate, their case should focus on the contribution that they were making to the national effort in the fight against the virus. For the time being, they should implement strategies to send staff home when they display symptoms and should be prepared to reduce opening hours when necessary. Helen's now going to take us through some of the other defences.
That's right, Lucinda, thank you. I'm going to look at contributory negligence and also VOLENTI. Dealing with contributory negligence, first of all, I'll only speak very briefly on this because we're all entirely familiar, I'm sure, with the issues relating to it. Here, it's likely to be argued that there was a failure to wear the kit properly, a failure to keep it on, although, of course, the claimant may well come back and say, well, you should have provided me with more rest breaks. And possibly an employee choosing to wear their own kit in circumstances where that wasn't provided to them. The more interesting defence, I think, is going to be VOLENTI, i.e. that an employee voluntarily accepted the risk of injury. Now, this is a complete defence to a claim, but it's generally been seen to have an extremely limited role in the employer's liability context, not surprisingly so, given that it's established law that a person can't consent to negligence per se, or at least there's an extremely high threshold. And VOLENTI is not a defence to breach of a statutory obligation owed by an employer. Given, however, that the regulations no longer give rise to civil liability, it's perhaps arguable that VOLENTI now has more of a role. We consider that there may be a very small number of cases where VOLENTI could be raised as a complete defence. So take the extreme example of an overweight male Black or minority ethnic employee who has come out of retirement voluntarily to return to the front line. It could be argued that he was aware of his own vulnerability and in particular was aware that there is a PPE crisis at the moment and that he was running the risk that he wouldn't get adequate equipment. All of these points, of course, would be relevant to contributory negligence, but it may be worth running the defence of VOLENTI as well in such a case. The defence may not receive the sympathy of the court, but then again, a judge may not have a great deal of sympathy for a person who has voluntarily put themselves at risk, knowing that they are particularly vulnerable to contracting COVID-19. I'm going to turn next to claims brought by family members. The most serious of these, of course, will be the claim arising out of an employee's death, and that would be brought by a dependent under the Fatal Accidents Act or by the estate under the LRMPA. There will be other possible claims, though, brought by family members. Transmissibility of the virus means that many key workers are concerned about bringing it home. Could a family member who contracts the virus after an individual employee has been affected also bring a claim against the employer? Well, there's an interesting parallel here in industrial disease cases in which the right of an affected family member to bring a claim is well established. So, for example, in the case of Hewitt and Alf Brown's Transport, which I placed on the slide, it was found that a duty was owed to an employee's family in respect of lead taken home on an employee's work clothes. And there are many cases relating to family members who have been exposed to asbestos dust. We consider that this point is clearly arguable, but of course the fact that there would have been liability to an employee doesn't always mean that there will be liability to the family member. There has to be reasonably foreseeable that damage to that particular claimant will be sustained. Here, of course, it's well known that the virus is highly transmissible, so foreseeability shouldn't be too much of an issue. But causation is likely to be much trickier to establish. the family member would inevitably have been exposed to others, and maybe argue that it was those others who passed the virus onto that person. So we think that causation is the route by which these claims are more likely to be easily defended. We've come to the end of our session today, and I hope that we have been able to answer at least some of the questions that you may have had, including those that have been placed in the chat function. Please do contact us by email, though, if we are able to assist further. I want to end by saying that this is clearly a developing area of the law, and I think all of those who are concerned with it are likely to have huge sympathy for those involved. We, as lawyers, are not on the front line of the crisis, however it may sometimes feel, and we must not forget that for all those involved, both employees and employers, these cases will be about individuals working incredibly hard to do the right thing in times of immense pressure. I certainly take my hat off to them.